Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. It's time to talk about some of our sponsors, and I'm doing that today with Robert Ingalls from LawPods. Today's episode is brought to you by Steno. Steno is a company that has rethought court reporting services. Not only do they allow plaintiffs' trial lawyers to defer the cost until the end of the case, but they've developed their own interface that allows you to better handle and manage exhibits and visuals during the deposition. Check them out.
And what is it about Steno that you really feel like is their main thing? What makes them special?
You know, I think it's really critical for lawyers to have that option to defer the costs of depositions, particularly in cases where you're doing dozens of depositions. It can be a very significant part of the overall case costs, and it's nice not to have to incur that until you get your money in at the end of the case.
And you can listen to the Season 4, Episode 17 with Steno President Dylan Ruga. We'll link that in the show notes for you.
Yeah, Dylan's a great guy and a really interesting episode, so I encourage you to listen and see what they're all about. Our show today is also brought to you by our friends at Expert Institute. They've been a sponsor of this show since the beginning. My good friend Michael Talvey was on the show, and Robert can tell you when that was. What was his episode, Robert?
So we had Michael Talvey on Season 4, Episode 22, and we'll link that one for you as well.
Yeah, and Expert Institute is really the go-to place now for plaintiffs' trial firms to locate the best experts to help them win their case. We've been working with Expert Institute for 4 years now, and they're an indispensable part of our practice. It's really hard for me to imagine going back to a day without Expert Institute. So they're a great company. They provide a great service, and I would encourage you to try them out. Today's show is also brought to you by Smart Advocate. Smart Advocate is the case management software that we use to run our law firm. We've been using it now for over 4 years. All of our staff and our team love it, and it's done a great job managing a complex docket of cases. Some cases are one-offs. We have cases where we have over 100 clients, so it's pretty versatile and a good program and good people. We also had them on the show, right, Robert?
Yeah, I think we may have had them more than once, but I think the most recent episode was with Claude Simpson. It was a bonus episode in Season 3, which will also be linked for you.
Our show today is also brought to you by FileVine. FileVine is a brand new sponsor of the show, and FileVine offers a product called Lead Docket, which is probably the best product on the market for managing new case intakes and leads. And if you're a law firm like ours that spends any dollars at all marketing to bring cases through the door, you know how important it is that you don't want to miss any of those, and you want to have an organized way to make sure your team follows up with every lead and turns any potential case into money to bring money back in the door. So Lead Docket is the best way to do that. Check it out and put it to work in your practice.
And I couldn't help but notice you have a shiny new website at GideonAsin.com. Who does that for you?
So our friends at Hype Legal, Micah and Tyler, we just hired them to redevelop our website. They did a wonderful job. The aesthetics are beautiful. The coding is really slick. They do a great job. It's a real pleasure to work with Micah and Tyler because unlike many of the other digital marketing firms, when you work with them, you deal directly with Micah and Tyler. You're not dealing with some young account executive that doesn't know anything about coding or your business. You're dealing directly with the principals. They're very responsive, and they've got a great eye for aesthetics. So check out our new website if you like it. Give Micah and Tyler a call, and they can do the same great work for you.
And I got to say, I'm hearing people say that somewhere around episode 2 of this podcast, it just started sounding a lot more crisp, really good, really professional. What happened there?
You know, it's funny you should ask that, Robert.
I'm the worst.
So we decided finally after 4 seasons of kind of winging it, and we did an okay job, but we thought we could do better and get better sound quality, have a better produced show. So we finally bit the bullet, and we've hired LawPods to be our official producer. So not only they've been editing the show, but now they're also producing it. So you can thank the better intro, the better outro, and the better sound quality to the great folks at LawPods. And if you're a lawyer who's interested in putting together a podcast for yourself, I would definitely give them a call. They can help you out.
All right, I think that's our ads. Let's get back to the content.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi. For the first time in forever, Ben's not here today. He's got a deposition that's going to be starting very soon, and I can't believe it. Feel like I'm, walking around naked right now. But Ben, we miss you. We'll see you next session. But this gives me the great pleasure of having my good friend, colleague in Vegas, Kimball Jones, Bighorn Law Firm. Kimball, thanks for joining us. Or me.
Yeah, thanks for having me. Yeah, well, I appreciate it. I've been excited to get on your podcast, Rahul.
No, this is great. This is great. And for those who haven't heard of Kimball, that's unbelievable. But Kimball has been on an absolute tear. Last year, over 30 days, had 3 big verdicts. This year in February, had another verdict over 100 million. And I know that I'm missing some in between. But before we get to any of those, Kimball, tell us a little bit about yourself. How did you even become a trial lawyer?
When I was in law school, I did a clerkship my 2L year with a firm, and I decided that I didn't want to practice law. And so when I finished law school, I went into banking for a bit. I was a reservist in the Army on the side, and then I went and I did that kind of active duty, became an intelligence officer for the Department of Defense, and did that for a period of time. And then a good buddy of mine from law school, Ryan Anderson, who actually started Bighorn Law, and then has actually gone on to start a pretty well-known company for a lot of us, Filevine. And Ryan Anderson was a buddy of mine from law school, and he recruited me to come to Las Vegas kind of mainly by just telling me the great stuff that he was doing. And I realized, man, actually practicing law is not the boring real estate stuff I was doing during that clerkship. You could actually represent real people, go to court, go to trial. And so to me, it was very compelling. I came and I took the bar in 2013 in Nevada and started working as a new attorney for Ryan Anderson at Bighorn Law. And that's kind of where it started. And in terms of being a trial lawyer, I really it wasn't an ambition of mine at all. I thought that I'd probably run the law firm eventually or run my own law firm eventually or something like that. But as I developed as an attorney, I started doing that actually. I kind of was in a position where I was running the law firm day to day, and I hated it. I really enjoyed working on like with a small team, maybe a group of 10 people or so, putting together cases and, driving a certain vision on cases and helping people. But I didn't like managing a large group that kind of went beyond that. And frankly, I don't think I was very good at it. It was not a natural skill set for me, and I needed to develop in a different way. At the same time, I have an incredibly talented partner, Jackie Britell, and she's just the kind of person that is, well, just unbelievably talented, but also you could trust her with anything. She's just an incredibly good person. And so she was kind of going through some issues where she wanted to be a trial lawyer, but it turned out she developed some congenital hearing issues. And it made it very difficult for her to be in court because she'd miss what people were saying. She couldn't hear them, literally just was going partially deaf. But she was very, very good at managing people. So we ended up kind of swapping roles intentionally within our firm. And so around 2017, maybe, I started really devoting myself to learning how to do trials. And I had an opportunity in 2018 to do a trial with this amazing trial attorney here in Las Vegas. I brought him in on a case. Dave Churchill is his name, and he's one of the most underrated trial lawyers I think that there are. He is just a tremendously talented and amazing guy. And he did a trial with me. We ended up losing the trial, but that's taking nothing away from Dave. There were circumstances there, but I went through that having an opportunity now to have watched a really great trial lawyer and participated in the trial. Doing a cross-examination of a neurosurgeon myself during the trial, and I came out of that. We lost this case for a really deserving guy, and I came out of that emotionally motivated in a different way than I think I had ever been before, and with a skill set that I didn't have before, because I'd been able to watch someone who really knew what he was doing do it. That's kind of a big part of it. And then from there, Rahul, I mean, I watched Keenan Ball stuff, so so I had a bit of a framework, and then. In reality, when I was introduced to you, I was at an NJA conference in California, and I was staying for the last day because I was super excited because Brian Panish was speaking. But it wasn't Brian Panish; it was Rahul Ravipudi, who I actually didn't know. I didn't know who you were at the time because I was a young guy that knew nothing. And you gave a presentation that was so incredible that I came out of that, and it made me realize one thing. It made me realize, just from a technical perspective, is you need to do PowerPoints in opening, and the power of using the defense witnesses in those opening PowerPoints was really something special. And I watched the way that you did that, and I had never seen anything like it. And up to that point, I had always done openings where it was basically a script that I would directly give with no PowerPoint, kind of the Keenan Ball method. And watching you in that just completely changed my vision of the way that these things needed to be done. And so, yeah, so that was kind of an interesting turning point. So after that, I've kind of, every time that I've seen that you were at a conference giving any sort of lecture of any kind, I have tried to jump in there and watch the great stuff you're doing, man. So that's for sure.
No, appreciate it. Okay, I want to take a step back here. So I've always wondered this because my first trial was a defense verdict too. I was a first-year lawyer. The boss I was working for, he brought me in on this case. It was the worst case ever. It was a guaranteed defense verdict before we even started, and we tried our best, and that was the outcome. But it was jarring for me on so many levels because there was nothing fun about going in, knowing you're going to lose, losing, spending, 2.5 weeks in trial with the judge yelling at me. And this is my first time in a courtroom almost. And I thought, this sucks. There's nothing fun about this. And I lost. So I lost like all this stress, all this anxiety, and then a kick in the stomach at the end of it. How was it navigating that loss? And tell us a little bit about that case and what you learned from it and what you took away that made you who you are today.
Unfortunately for me, that was actually my fourth trial, and it was my second loss. But yeah, so I took on a case during my first year as a lawyer that just walked in the door. He'd been dropped by like 5 attorneys, and his trial was in 3 weeks or something like that. And I picked that up. It was a 1-day trial here in Vegas, and I got a defense verdict in that case. And that was a bummer. The next 2 cases I did one with Ryan Anderson. He's actually a very, very talented trial lawyer. We won that case, but just barely. Got a little bit of money, $1 above the medical bills, actually. Then I had another little short trial where we got a little bit of money. So this was my fourth trial, the one I just mentioned. And it was a great case. Rahul, is one of the best cases I've ever had, and one of the most wonderful clients I've ever represented. And his name was Caesar. And he had been crashed into, rear end crash, and there was a dispute as to whether or not he had cut the person off or not, resulting in the crash. But the evidence for that was very, very thin. We had a dynamic. It's the only time in my career that I would say this. We had a judge who was against us, and at every turn from jury selection throughout, took every action she could to hurt the case. And I don't even know how to say it other than that. She's retired now, but it was incredible. I've never seen anything like it. And And that's just what happened. And for example, during Dave's opening, she said that each side would have 1 hour for opening. And she cut Dave off at 45 minutes, literally didn't let him finish his opening, things like that. And then somehow we appealed it and lost the appeal. But Caesar was seriously injured from the crash. He had suffered a brain injury and had brain surgery related to it. And there were some causation arguments related to pre-existing conditions and things, but I didn't feel they were very strong, frankly. And around the time, just shortly after Caesar lost his appeal, he actually passed away. And I was in his hospital room with him, near the end. And it was a horrible experience, and I loved Caesar, and he was just a very deserving guy. And so when we lost that case, I fully expected we were going to win. I thought we were going to win an 8-figure verdict because I knew the evidence that had come out, and we lost. And it was, I'll tell you, I didn't sleep well for a couple of months. And, every single thing I second guessed every decision we made in the case. And I just analytically thought through everything you do in a trial in a way that I wouldn't have done, I don't think, if we had won. And I came out of that realizing, man, don't give up anything the defense wants. If they want it, it's a reason to not give it. And so, there were little things in the case, like we just agreed to introduce the medical records, just stipulate that the medical records were all admitted. But we didn't need them, and the defense did in the case. We had witnesses that could testify about everything, and we really didn't need the records. And the defense would have had a difficult time introducing the records. But what happened is the defense then took them out of context and essentially lied about what they meant. And so we combated that, I thought, pretty effectively. But when you have a biased jury to begin with, because of the nature of how things got set up for the judge, they were looking for any reason to not be in our camp. And without those records, I don't think they could have even had a reason, as biased as they were. It was a strange dynamic. It feels like a long way since then. This was in 2019, but our client he was from Mexico, and he was a gay married man. And I'll tell you, there was a bias against him related to those two things, being from Mexico and being gay, that I just didn't realize would still exist, frankly. Like I was very naive about how that could actually be an issue. But I realized afterwards it was an issue. It was a huge issue. We had one of the jurors afterwards. Actually, the foreperson was on our side. It was a split jury, and they deliberated for like 3 days. And then it was split 3-5 against us. And then one of the jurors flipped to get the thing over with, basically, to not be involved anymore. And so we found out afterwards that there was a lot of commentary about him being gay, and that probably his brain issues related to a sexual lifestyle or something. I mean, just really, really extraordinary things that are, there was no evidence of that. Of course, it's just not realistic scientifically. And so it was pretty goofy, but there was some bias there that was problematic. And coming out of that, I just realized, I think more than anything else, that just be careful about what you agree to. Agree to nothing. That you just bring in only what you need. Don't agree to anything that the defense wants, basically, unless you know for sure that it's not possible to hurt you. Things like that.
And then what did you learn from David Churchill about trying cases? Where was his strongest points?
Oh, he was so, honestly, he's good at everything. So, in voir dire, he was very good. He's a talented guy talking to folks in voir dire. He's a guy that's constantly learning. So he had just gone to like Sari de Lamont a little while before, had learned some really great just techniques of how to deal with the jury, how to kind of discuss a collision. The opening was very strong. In cross-examination, the way that he was able to draw out and really spend some time and focus on absurd responses by the defendant. It was special, right? He'd just pause. So he'd say, okay, so you answered the interrogatory this way, and it's just obviously very absurd. He's like, but just in a very understanding but tongue-in-cheek way, like, oh, okay. And when you signed the affirmation here, what does it say right there? Oh, that's under oath, right? Oh, okay. And so you said this, and that was under oath. And just his way of just making the pain stretch out as long as possible. It was beautiful. It was really good. He has his own way of doing that. I can't really duplicate exactly. All of us have kind of our own things that we're particularly good at. That's something that I saw that I've tried to duplicate, but he's pretty remarkable in that area. He's very good. Another thing is when there's evidence that isn't there, he just was really good at highlighting how it should have been there and the importance of it in a way that I hadn't really appreciated before. Anyway, he was just good across the board.
What do you mean by that? The absence of evidence?
Yeah, so as you know, in many cases we deal with, destroyed or spoliated evidence, right? So people claim they like took pictures, but the pictures weren't there. And so maybe in like the deposition, somebody had said, well, yeah, we know it was that way because we like took pictures at the time, but they didn't have the pictures, right, anymore. And so even though the judge didn't give us any sort of a spoliation instruction or anything like that, you can still deal with that evidence on cross-examination, and it just completely crushes the credibility of the person that's there that has destroyed this evidence. And Dave was just really good at kind of drawing that out and explaining what that was. In closing, we split closing. Dave did the close, I did the rebuttal close. I felt like both of us did a good job. Another thing was, like, even though Dave was the guy in charge there, it was pretty cool how he let me do some things, right? So the primary defense expert, he let me do the cross, and it was a really big moment for me. I felt like it went really well, and he was very much just a cheerleader for me when things went well, in a way that like really pumped me up. And I came out of that trial devastated by the loss, but really very, very strong confidence that, you know what, this is never going to happen like this again. You know what I mean? That was kind of my feeling coming out of it. And the next year, my highest verdict up to that point was like $26,000, and my next verdict the next year was 13.6 million in a pretty challenging medical malpractice case. And really many, huge part of it was the things that I learned in that trial with Dave, even though we hadn't won.
Amazing. Going from 26,000 to 13 million. And now on the medical malpractice case, I have two questions. Why did you get involved in it? And what are your thoughts on them, I guess, in general? I should have said three. Were there any caps that impacted the total judgment on that verdict?
Yeah. So there's number one, I got involved in medical malpractice cases because as kind of a new firm that was kind of young with no reputation, right? We had never won anything big, frankly. You get a certain type of case referred to you, right? And so occasionally we'd get a bigger case, but they were few and far between. And so medical malpractice cases sometimes would have massive damages, but they're very challenging because there's a huge bias in favor of doctors and because of a variety of other things. And so what happened, I was just fortunate that a guy who for some reason could tell that I was really good, but even though I had no results to really back it up, came to me with this medical malpractice case and asked me to get on board and basically be lead trial counsel in a case that was coming up for trial in like 4 months. And so we did the trial together. His name was George Hand, and we did it with another partner of mine at the time named Jacob Levitt. And so we did that trial, and it was a great case. Our client, Tatina is her name, just amazing person who went in. The surgeon was super sloppy, frankly used the wrong tools during the procedure, and ended up perforating her bowel in a hernia repair surgery, and then left her for a long period of time without fixing it. And she became septic and had bilateral foot drop as a result. And so it was this really tragic case. Unfortunately, after we got our big verdict, well, first of all, the caps in Nevada are such that the case, the 13 million, was reduced down to like, I want to say 7 million or something like that. But then after that reduction, it went up on appeal and it got reversed and remanded. And so we ended up not keeping the verdict. We ended up having to go, and we were doing the trial the second time, and we ended up settling the case. Frankly, I felt very confident that we were going to hit the same verdict or bigger the second time around. We ended up settling the case the day of the second trial, that the second trial began.
What was the ground for reversal?
So the doctor had another case, just a few months earlier, where he had done the exact same thing, essentially. During a hernia repair surgery, he punctured a woman's stomach, and then he kind of engaged in a little bit of a cover-up, similar to how he had done in this case. And then in our case, he lied about that. So he lied about it in deposition. He was untruthful about his history of malpractice, covered up this case that had ongoing litigation. So when I got involved in the case, we discovered what all of this had gone down. And so we immediately made a big issue of it. And the judge was in agreement that this was a cover up. And so that information about that case to some degree was permitted to be discussed in our case. And the Nevada Supreme Court ended up saying that was error to do that, which was just nonsense. And in my view, I was very upset with it. I still am, obviously. I think that Tatina deserved that verdict at the time, and that it was unfortunate. So it is what it is. I certainly have I've taken the lesson learned there, and I've tried to be even more careful, about how you do it. So, but yeah, so that was the basis for the reversal. And
That doesn't
I
sound
felt
like I'm with you on that. I mean, if there's impeachment grounds and other grounds to bring that in, then that's on the doctor. That's not on you.
that's how I felt. I mean, the doctor was such a liar. I mean, it was so bad. And at trial, it was so evident too. Yeah, it was really too bad that it was viewed that way. That was a bummer, but those things happen, and then you move to the next one. For me, after that, Rahul, we had COVID, so I was a little bit concerned that even though I had some confidence, I was worried that am I kind of a one-hit wonder on this because I couldn't get into another trial. But then eventually we did, and in the end of 2021, the court started opening again, and I started being able to do some more trials, and then had some, fortunately they went well.
Every
So
judge in Nevada had different rules during that time period as to how the trial would be run. Did you get into any courtrooms with no social distancing in 2021, or how did it work out?
no, I mean, every judge I had in 2021 was just kicking everything. They were just moving everything out to the next year. And then, but then we went into one, we had a pre-trial conference where trial was like scheduled for 3 weeks away. I was certain it was going to be kicked. So I was just kind of anticipating that. And our judge, great judge, Judge Nadia Krall, we go to the pre-trial, and she just says, yeah, you're going to trial, guys. It's in 3 weeks, so bring your masks, and that's it. Like, it's happening, and so we're like, okay, great, let's go. So sure enough, 3 weeks, we went and did the trial. That was all there was, and she was not hearing. Like, the defense had a million excuses. She was not hearing it. And from our end, we kind of were afraid to go because we didn't expect that a little bit. But how you put on the brave face and you say, yeah, hell yeah, let's go do it.
Right, right. What do you think about trying a case with a mask on?
Honestly, it wasn't too bad. My partner Jackie, well, no, we actually didn't do clear ones. We just did the normal masks. But someone gave my partner Jackie the tip that, like, you should chew gum in the mask, and it actually helps with your breathing and ventilation or something. It was kind of weird. So we did, and it actually was totally true. It was like super helpful. So I felt like it didn't really inhibit us much doing it with the masks on. I was pretty comfortable, and the jury did a good job. It was a case that had some challenges, and we felt like we got a pretty good result. It was a case with we had like 32,000 in past medical, which we waived, right? And but there was a brain injury in the case, and the diagnosis, the treatment for it was being attacked because there was like a 3-year gap in treatment because our client didn't really know what to do to get help. There wasn't really a lot of help for her that she was able to find. So anyway, that was kind of what we were dealing with, and the jury returned a verdict of 1.6 million, and they initially wrote down 4.3 million, and then erased it, put down 1.6, and they explained afterwards that it was because the defense attorney argued in closing about the negative impact, essentially made a poverty argument in closing, and the jury felt bad about it, so they reduced it based on that. And then, like, I swear, like a month later, there was a decision by the Nevada Supreme Court that opens the door to an instruction that insurance is covering everything. We didn't have that law before then, and frankly, I didn't raise the issue because I just didn't appreciate the legal significance at the time. But we still got a result that was good, and the case went forward and was affirmed, and so the client ultimately got paid. And that was a $25,000 policy, by the way, that State Farm refused to pay. So
Crazy.
they ended up paying, I want to say 2.8, 2 point something like that when all was said and done.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
Have you done a number of open policy trials?
I have, yeah. Yeah, so I've done quite a few. I'm very careful. I make sure that, if I'm going to do those, obviously they're very expensive. They're like any other case. They're well defended, and the experts and everything. So they cost a lot of money. So you want to make sure if you do them that you're doing good cases, right? That are going to last through that second case. So we did that one. In 2023, we had one that was a $15,000 policy that hadn't been paid on time. And we got an 8.9 million verdict. It's a nationwide case. And that was also affirmed by the Nevada Supreme Court, and it is currently, the bad faith litigation is ongoing. The defendant is represented by another attorney going after nationwide. And then recently, just last year in October, we got a $550 million verdict in a wrongful death case. Is an open policy with USAA. They, for some reason, decided that they didn't have to represent or defend the actual driver, and they only included the owner in the release and the settlement documents and left the driver hanging out to dry. I still don't fully understand the goofy thinking that went on there, but anyway, that's what happened. So they blew the opportunity to settle for the driver, even though he was included in like the settlement materials from us requesting settlement. Then they turned around and didn't include him. They took him out of the settlement documents for some reason, and then didn't represent him for like 3 months in litigation until we got plain admissions that he was driving the vehicle with permission and hadn't stolen it or anything like that. And then all of a sudden they came in and started defending the case. But it was a wrongful death DUI case, and we got a $50 million compensatory verdict for the wrongful death and the injury to the widow, the Escobia family. And then the jury awarded $500 million in punitive damages on it. So that was, that's the largest verdict that I've had in my career, and that was an open policy case.
Wow.
Could have settled for 25, yeah.
So who was defending the case at trial?
George Rinaldi. He's really good. He's, I think, one of the best trial attorneys in the state of Nevada. He's really, really good. It was an impossible case. There was no way this case was not going to go well for us. And it went obviously very well. I mean, someone told me that it's the largest verdict on behalf of a single person in the history of Nevada. It was an impossible case to defend. You have a wrongful death DUI, driver going 107 miles an hour in a 45-mile zone, and runs, goes into an intersection and T-bones this husband and wife on their way to church. And a horrible case. And the aftermath of it was so bad. You could see how it completely, it was terrible. And the evidence at trial was so strong of the terrible impact that it had on the family and everything. And the crash also was captured on video, because after the crash, our client's vehicle went flying through the air and hit the side of a bus that was at a red light. And so this transit bus had all of its cameras go off, right? And so we actually have the crash on video. So we were able to show that to the jury too. It wasn't overly graphic in terms of humans being, the injury to the people, but it showed the crash really well. And it's traumatic just to watch. You can just see the massive effect.
Oh man. So tell me a little bit about some of the turning points. The evidence obviously sounds incredibly powerful, but a $550 million verdict. How did you make that happen?
Well, first of all, let me give a hat tip to my partner, Josh Barrett, who really handled this case throughout litigation and did the trial with me and was critically important. We also had Emily Cunningham, who was an attorney that worked on the case, did really good work in trial in the case, including she really developed a connection with one of the family members And really, there was this emotional breakthrough where the family was very solemn and wasn't super expressive about what they had suffered. And I really felt Emily did a nice job of connecting in such a way that there was this feeling of trust that we were able to develop just beyond what is normal. And so by the time we got into trial, it was pretty cool. The family really opened up and told the jury what they really went through, and it was pretty powerful. I think there were things in jury selection that I thought were a big deal. One thing, and this is something I took from you actually, mini openings are sometimes permitted, sometimes not permitted in Nevada. But you have talked about how in mini openings, how you think it's important to get the number out there every time in the mini opening. And this was frankly the first time I think ever that I've done that. It is the first time I've ever done that in a mini opening. But this judge was doing a mini opening. And so I had a very simple mini opening script that was, just I don't know, it was a few sentences long. It was something along the lines of, try to think of what I said. It was like, this case involves a car crash with a wrongful death. We are seeking punitive damages in the case as well. We believe this is a very important case in our community, and we're recommending a verdict of over $50 million. Anyone who ends up having the opportunity to be on this jury, we believe you'll be grateful that you had the opportunity to do this in the end. Thank you. That was basically it, something like that. It opened things up so that $50 million was something that could be dealt with right away. And jurors brought it up on their own about whether or not that was reasonable. So we had this conversation about it. And I was able to say, yeah, look, we're going to be recommending that the verdict be between 55 and 85. We think that those are the ranges of what a reasonable verdict is in this case. And of course, we have to prove that, right? That's not on you to prove, that's on us to prove. But if we do prove that, who here would just feel like that's just not something you could do regardless of what the evidence shows, right? And so, you're able to get in and verify. And they didn't give us 55 million or 85 million, but they gave us 50 million, right? And there was not a shock effect to the amount of money, and the amount of money was super reasonable. That was the view. And then when it came to punitive damages, I thought I always think punitive damages are very hard for the defense to deal with. And so when you have punitive damages on the table, they have to come in and they just got their ass kicked. They just got hit with $50 million and they're recovering from that. And then now they have to talk to this jury about giving some modest amount of money for punitive damages. And so my pitch on punitive damages was thinking about the appeal that was to come. I said, the defense attorney had said that in the compensatory phase that now was not the time to be excited or angry when they give a verdict, that would have to come, in the punitive phase, and that, they shouldn't give too big of a verdict or something. So at the punitive phase, I said, so you remember the defense attorney said that, that now is the time to be angry or whatever, right? You remember that? I said, no, it's not, guys. It's not. This is the time to think about the message that you want to send based on the behavior here, the message you want to send to the community. It's not about being angry. It's about sending the right message, right? And so I was pretty calm and deliberate there to frankly try to calm the situation and make them really think about it. Because in my view, you may agree with me, I feel like a calm, deliberate jury is actually way, way better than an excited, pumped up jury, because our cases are very righteous and what's happened is egregious. And calm people thinking reasonably about it tend to value really highly what they're evaluating. And so in this case, based on the facts of the case, I said, a jury doesn't often know what to do in a situation when they get to punitive damages. And a way to think about it is, some people say, well, is this the kind of case where punitive damages should be 3 times? Or is it the kind of case where punitive damages should be 10 times? And so that's a decision for you guys to make. What kind of message do you want to send? Is this a 3 times message case, or is this a 10 times message case? We think that the conduct here is very, very bad. And so our recommendation is a 9 times damages award. That was what we said essentially. I mean, it was a pretty short argument. And then they ended up doing a 10 times award. The jury did.
What was the close on the part of the defense in the punitive phase? Did they acknowledge wrongdoing, or for their appellate purposes, did they say, hey, we disagree with you, ladies and gentlemen of the jury, that, with your primary award and finding of punitive damages, but here we are?
It was definitely a more sober approach. I don't know that I have the only criticism I'd offer about it is there was a recommendation for zero in punitive damages. The statement made was something like, 50 million is an enormous amount of money. I will tell you, like, the message is received, it's understood. This is a huge amount of money. We recommend that you don't award anything further, with respect to the punitive damages. And I just think that they just checked the box. It wasn't like they were confused that the compensatory was part of the punitives or something. They knew what they were doing. They had an intention of awarding punitive damages. They knew that was coming. And you could just see they were turned off by it. But I don't know what the right answer is there. What does he say? A $20 million punitive damage verdict or something? I don't know. Maybe there's a number he could have given, but I'm not sure. I've seen it go both ways, because I'll say we got punitive damages in this case that ended on January 31st against USAA, and we got 100 million in punitive damages against USAA in that case. And in that case, another very skilled attorney did recommend some amount. I don't remember what he recommended, but he didn't recommend a zero. He said, hey, we've heard you loud and clear, and he recommended some small amount or something like that, I think. So I've seen it go both ways, and I'm not sure, frankly. Here's the thing. Just don't engage in that kind of behavior, or else pay money to avoid the trial. Because when you get to the punitive damage phase, there's not a good argument for the defense. They can say whatever they want to say, but it almost just can't be good.
Yeah. Yeah. Especially, when the jury checks that box saying that malice, oppression, fraud, punitive damages are warranted. And then you come in there as the defense lawyer and you've got to come in and still say, let's, cooler heads should prevail or whatever you want to say. It's like you're either patronizing the jury or you're misreading the room and trying to argue things that they've already decided. And then you just take away your credibility. So I totally agree with you on the calmer jury thing also, in part because they then can appreciate who's actually being honest with them and who's not, and parsing through that. And sometimes it's hard to do that if your temper's going, and it may backfire.
Yeah, I totally agree. I think it's one of the most miscast concepts. I mean, almost every verdict I've ever had, where I've had a good verdict, there's always some stupid argument in the appellate brief about passion and prejudice of the jury. Fortunately, most of my recent trials, at least, are on CVN. And you can watch the approach that I have versus the approach the defense attorney has, and the calm, deliberate nature of the arguments that we're making on our side. We are seeking reasonableness. We are seeking a fair shake. And that's the last thing the defense wants, right? They want to muddy the waters. They want to make it confusing. They want to hype people up into emotional states so that they can make irrational decisions. And so it's an interesting thing that I think that's been my experience pretty consistently, frankly, that's how all of my good verdicts, I don't think that there's been a single one where I have this passionate, jury that's all super excited. Frankly, most of them, they're like very somber. And even though I know we've put on this really amazing case, I'm very proud of the team and this great case we put on together, and even though I feel that way, I really don't have a great read on the jury because they're not telling me where they're going with their visuals, Frankly, in the last trial, that's exactly how we felt. We put on. So Josh, again, my partner Josh, just did an amazing job in this last trial against USAA. He handled the case throughout litigation. We did the trial together, and then we did it with Emily Grable, an attorney in our office, and she was amazing too. She did such a great job. But we all, looking at the jury, there were a couple of good indicators from a couple of jurors, but for the most part, the jury just not being super emotive, and we were not presenting a case that was drawing out emotion. We were presenting a case that was, this is what they did, guys, and this is the harm it caused. And so the jury comes back and does a reasonable thing,
Now, just getting this string that happened over the last couple of years in particular of really significant verdicts on behalf of your clients, is there and one after the other, after the other, after the other. It's remarkable to see, and I'm so proud of you and your firm. Have you guys kind of built out a system of how you're working up the cases or how you're going to present the cases to to get these types of consistent verdicts?
For sure. As every case is its own case. And so in some ways, yes. I mean, it was helpful. We had a large verdict against Progressive Insurance related to first party bad faith, a UIM case. And that was in August. And so then doing another UIM bad faith case against USAA in January, there were some things there that are similar from one case to the next. However, the behavior and the particular systems that led to the really terrible treatment of our clients was different from one case to the next, right? It was not really the same. The framework was different. So for sure, we have systems in place where we get together and we evaluate the case. We find out all the ways that our case might have different issues that we need to be concerned about. We need to look at our strengths, weaknesses, and kind of handle them appropriately. But I don't think anything out of the ordinary. One thing I will say is this. I learned a long time ago that you need to attach yourself to the right people. You need to be with the right people, and that anything great that you ever accomplish is almost certainly accomplished by a team, and it's not accomplished by you. And so it's, this idea of patting yourself on the back because you have a name that is getting some credit. Get rid of that bullshit because it really is. There's this team dynamic that makes anything possible. And I think that's one thing. Years ago, I watched a ESPN special about the Pistons from the 1980s, right? And the bad boys. And Bill Laimbeer was talking, and he talked about how when he was early in the league, they got this guy named Isiah Thomas, and he sees Isiah Thomas and what Isiah Thomas can do, and he realizes this guy is special. And if I attach my wagon to this guy, my career is going to go farther than it ever will if I try to do this on my own. And so he connected himself to Isiah Thomas, and that was the way that he approached it. And I thought that was brilliant. I thought that was so smart for him to do that. And I think that's exactly true, that it had that result for him. And so, when I look at things like that, I have found that that's the answer in life, right? So, my wife, when I met this girl that I fell in love with, she had these attributes that I wanted to be attached to her, right? And that by being attached to her, I was going to be able to do far more in my life than I could do on my own. And then when I came into this law firm, and I attached myself to Ryan Anderson, I'm attaching myself to this buddy of mine from law school, but it wasn't because he was this buddy of mine from law school. This was a guy that had a vision that I couldn't even comprehend, but I could see that this guy could see stuff way out in the future that I couldn't see. And it was amazing. And he had the work ethic to drive those visions forward, right? And so I attached myself to him. And a little while into my career, I meet this new associate that Ryan hires named Jacqueline Britell. And Jacqueline Britell is unbelievably talented. And as I get to know her, she's also incredibly good, trustworthy, just the kind of person that you want to be a partner with, right? And so, so I attached myself to her, right? And then you go through. And so Josh Barrett, who I've done these last two trials with, right? And I have a paralegal named Amy. And, we have a former paralegal who is an important person in our firm named Erickson Finch. And so these are people that I have found, these are my Isiah Thomas people, right? And so I found that that's the answer to this. And so if you want to do great things, you do great things with the people that can help you do great things. And then you go do great things together, right? And so I would say if there's one lesson on it, it would be that. And I would say in particular, when it comes to a trial team, I saw early on by watching Bob Eglett in a trial, by watching Dennis Prince in a trial, by watching Sean Claggett in a trial, that the way that they operate in trial is they have like 8 guys that are working on the trial with them, right? It's not just Sean Claggett up there, right? It's not just, and so when I realized that, I had been trying to do these trials with a tiny little team, me and a partner maybe, right? And we'd go do these trials with a 1 or 2 man show, and we were having good results. But I knew that if we wanted to take this to the next level, we had to be the next level team, right? So I think those are lessons learned. And so when we go into trial now, it's not 1 or 2 smart people figuring this out. It's not 3 or 4. It's like 10 people that are figuring this out together. And so even though I get to be the beneficiary of the guy that maybe does an important cross-examination or does a closing argument or something, so much of that has come together because of an amazing team, you know what I mean, that has allowed that to happen.
So true, especially with the way litigation is going these days. It's almost impossible to do it by yourself. And that's great, a great tribute to your team. And I'm sure they all see you the same way. Now, I got a question though. Isiah Thomas, he was a cool guy. Everybody liked him. He had that awesome smile. Who on your team's the Bill Lambier?
Yeah, I think I'm the Bill Lambier, man. I mean, that's a good question. When I think of that story, I feel like I'm the Bill Lambier. So, I'll go in there and I'll throw some elbows, man. I will break some glass. I'm not worried about it. Yeah, I don't mind getting dirty in the paint. And so, if that's anyway, I don't mind being the fighter, but it's a good question. I'll tell you, there's probably a few of us. One thing, Rahul, I convinced my wife to go to law school. She kind of convinced herself. So she's in her last semester. I have two brothers that I convinced to go to law school after military careers, and they both work at our firm now.
Yeah, I met your brother at the last TLU event. I've seen him at a
Yeah.
couple actually, but cool guy.
Yeah, yeah. So those guys, my brothers, in particular, one of my brothers, Danny, he's another Bill Lambier. I'll tell you, he's constantly in these last few trials. He'll be there and he's whispering in my ear, the damage that we need to do. Right. Anyway,
That's
yeah,
great.
we have a few people on the team that kind of fill all of those roles.
Now, tell us a little bit about the work-life balance. You've got 4 kids,
Yeah, yeah.
and your wife's now in law school. I mean, that's got to be, a lot of stuff going on at home and a lot of stuff going on at the firm. How do you manage it all?
Yeah, I heard a guy describe it on the Zoom founder. I heard him describe how this happens. And he just said work-life balance is the wrong way to look at it. You prioritize things and you do the things that require priority, and your family is always first, right? So your wife, your children, that's always number one. And so if there is something where they need you, then that is the priority over work, period. That's all there is to it. But you don't go about trying to balance stuff. That's an exhausting concept, and it's not a practical way to live a life. And so I thought that was really powerful. And I feel that it really spoke to me in the way that I view it too. So I work really hard, I find a lot of guys who talk about needing to get home at, 5 o'clock, so they're there for dinner. What they're really there is they need to get home so they can play, Call of Duty or play some video games or something, and maybe, some people are probably not that way. Some people are probably there playing board games with their kids every night for 4 hours or something. I don't know, but I kind of suspect that's not often the case. But I love to spend time with my kids. I try to spend my weekends in a meaningful way with my kids and my family, but I work really hard. I do. And I enjoy it. I enjoy the work. I'm very dedicated to the clients that I have, and they need us. You're dealing with real people that really need you, and oftentimes you're going against an army of highly paid attorneys from some mammoth corporation, and they start knowing who you are, and they put in that much more work, and you have to. This is something that I've dealt with, the last couple of years. You've been dealing with this for many years, Rahul, but you end up going against the best that money can buy, right? You need to make sure you do it well. Give your clients a fair shake.
Yeah. No, that's great. That's great. Well, you've been doing such an amazing job on behalf of your clients and the community. So thank you for all you do. And thank you for joining me on the podcast. I think we're at the tail end. But then one thing, if anybody wants to reach you, Kimball, what's the best way to reach you?
Yeah, they can reach out to me on my cell phone. It's area code 801-361-9996. They can reach me at my email, Kimball, Kimball, at bighornlaw.com. I try to be available, happy to help. People call me for tips on kind of some of the cases I've handled, especially bad faith cases, and I am happy to share anything I can with anybody. We're all in this cause together, helping real people who really deserve help. And really the only way that we can do this, in my view, is we have to be able to present a credible threat to the powerful folks that don't want to do the right thing. So it's a pretty meaningful thing that we do. And so any help that we can give each other, we should. And anyway, Rahul, you've been amazing over the years, man. So I'm so proud to have been on your podcast.
No, thank you so much. And I'm looking forward to seeing you again soon. Thanks for being here. And then we got to have you back on soon to get into more details on some of these cases and verdicts that you've gotten. But I have a feeling if I wait 3 months, we're going to be talking about a whole new string of massive verdicts. So I'm looking forward to hearing about those too.
Thank you, Rahul.